Ms. Knipfer.
May it please the court, counsel? One of the common tools used in criminal prosecutions is the use of prior bad acts evidence to prove mens rea. And in order to limit the misuse of this, the court has had Rule 5.404B, which says evidence of crimes, wrongs, or acts is not admissible to prove character of a person in order to show the person acted in conformity therewith. And then it adds an exception. It may, however, be admissible for the purposes such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accidents. The reason this rule was created, well, it's a common law rule, but why we continue this is that it was founded on a concern that juries tend to give excess weight to prior bad evidence, and on the principle that people should be judged on the acts of the crime for which they're accused, not some acts from their past. Until recently, the court has generally expressed the test for this rule as, first, there must be shown that the prior bad act is relevant and material to a legitimate issue or a fact in dispute. And
you talk about the weight that juries give. Here's one problem that I have with your position in this case. The prior bad acts came in through the victim's testimony, right?
correct.
And the defendant's whole theory was that the victim was lying about this domestic abuse. It didn't happen the way she said it did, right?
Correct.
So if you're sitting on the jury, how is it going to kind of move the needle significantly to have the victim talk about, in what was very plain vanilla fashion, a few other prior incidents? Because if the jury's either going to believe her or not. The fact that she mentioned some other incidents that he allegedly did to her is not going to really, kind of advance the ball. That's one problem I have. Help me.
Well, I think to the contrary, that it does advance the ball insofar as the jury is going to look at these prior acts, and they're going to say, or there's a risk that they're going to say that, well, he was a hothead here, here. He must have done it this time also.
But counsel, isn't that a risk that this court has seemed to tolerate, at least in the Taylor case and Rodriguez? Both of those, as I recall, were cases in which the defendant was alleged to have committed domestic abuse against the same victim on earlier occasions. And so it strikes me as I reread those decisions that we have sort of made the determination that in the case of domestic abuse, the fact that the state can prove an existing emotional relationship between intimate partners makes those cases different than other 5404 analyses. So tell me why I'm wrong, or distinguish those cases, or why haven't we already decided this?
The distinction between those cases and this case more so is, one, this case is spread out over a period of time, and those cases, I mean, not necessarily all of them, but a lot of them are more recent in time, and also there tend to be cases where those acts are directly tied in specific ways to the act that the defendant is on trial for. So in the case of Taylor, she got a temporary protective order. And he wanted to change, or he wanted to have contact with her, so he was violating that. That protective order was the instigator in the violation of the act. They're all real recent, they're all connected. In Newell, that one's he had been making threats, and he was very controlling, and all the acts go to controlling behavior, and the belief is that when he committed the murder, it was in retaliation for her not showing up in time, and that was suggested in there. But again, it kind of went to that controlling behavior. And in Rodriguez, he made threats the day before, and Edwards, he made threats the day before, and then he carried those threats out the next day, and that the injuries that were there were injuries that he had threatened the day before. So there's a more of a direct tie in their prior bad acts and the act that takes place when the crime is committed, where these aren't the acts of a there's nothing saying that they're controlling and he's trying to keep her from leaving him. And I recognize that she says that day he's trying to get her to leave him, but at the same time, I mean, he's kicking her out, and she's not living with him and under his control in the home, or she's not trying to separate, in the whole relationship, separating herself. I mean, these are two independent people. This is not, as I said, a controlling relationship.
We really kind of have to overrule Taylor to agree with you.
No, I think you can make Taylor more explicit in what the relationship between the prior acts and the act and ultimately in question.
Taylor involved, I mean, we specifically found Taylor that intent was an issue.
Yes.
Is intent an issue in this case when you read the transcript and the guy says, I grabbed her on purpose and I was throwing her out of the room? And I mean, if you read page 61 and 62 of the appendix, it looks like to me
Intent
he's
is
saying, I intended to do what I did.
Intent is an issue about whether he intended to assault her, cause harm or contact. And so,
If it's in self-defense, don't you, when you do a self-defense, don't you say, I admit the crime, but basically, I did it to protect myself? I mean,
Correct.
so how's intent an issue in that case?
well, I mean, then I guess the intent is his intent to defend himself. His acts weren't to harm her. His claim is his acts weren't to harm her, but his intent was to defend himself, not harm her.
So how does that distinction that you've just drawn between the intent of the actor who's defending himself and the actor who is intentionally assaulting someone, how does that distinction make a difference with respect to the probative force of the prior bad acts?
Well, I mean, for the situation here is those prior bad acts, they weren't the same kind of circumstance. I mean, the prior bad acts that she alleges were all just, I would say, short fuse, where here you got a claim of defense, and those don't really go to a justification situation. But I think you kind of, everybody's making claims of different kinds of intent, and that's for the jury to decide. I think the bigger problem in this case is when Putnam clarifies that we really have a prong of clear proof, and Putnam's correct that this is not a new standard. It actually has existed all along, and Sullivan points out that you have to show the relevance, and then you establish clear proof, and then you have a prima facie case for the admission of the evidence. But here, the problem is we don't have clear proof. We have, for clear proof, you have to have evidence that's beyond speculation or any beyond speculation, and you have, or to establish that, you can have testimony of a credible witness, and there doesn't have to be corroboration. But the problem here is the only witness is Trish Powell, and Trish is not a credible witness. I mean, her testimony in regard to what happened that day is just, it's beyond belief. And the other problem is, I know you don't have to have corroboration, but the trial court said that he found her testimony to be credible, and because there were other witnesses to these prior bad acts, he felt that there was clear proof. But there weren't any other witnesses insofar as no one came in and testified but Trish Powell as to these prior bad acts. And as
But, I mean, I read it, and her testimony is very detailed. And then the judge, I think appropriately, you know, we can decide whether it should have been admitted at all. But if it's going to be admitted, he sanitized it very much. And then, like the incident where she describes in great detail throwing the phone, then he takes the stand and says, oh, I wouldn't do that. Insurance on phones is too much.
Mm-hmm.
I mean, you know, it does seem to me that the evidence came in through her testimony that was very specific, right?
yeah, but I mean, people can be very specific without necessarily being credible, because his response to what happened was very detailed also, as far as, you know, the events of that day. But yet, one of them is not telling the truth or the full story.
Okay, granting that, what is it about her testimony that forms the basis of your conclusion that her testimony was completely incredible?
Well, I think it's not that as though you can say it's just incredible, but it seems to me like it's not credible insofar as when the testimony for what happened the day in question, in that I find that not credible insofar as she's saying that she got on his phone. This is a woman that wouldn't allow him to have any contact with the mother of his ex-girlfriend, and wouldn't even, you know, she made him go through his mother to make arrangements for his daughter. And yet she says that she read this Facebook message, which she claims is alleging, you know, all these prior sexual relations with her, with the defendant, and that she calmly tapped him on the shoulder. It's very doubtful. Let's put it that way. I just
Well,
find
but those
it
are all
suspicious.
those are all things that we leave to the jury. It sounds like, you know, she gave a very detailed explanation for the assault. He gave a very detailed justification for his self-defense, and then we leave that to the jury. So I'm not that interested in some of those arguments about whether there's credibility of the witnesses or not, or if it's incredible or not. But how does the other instances of alleged domestic abuse, how does that tilt the scale, I guess, in favor of who you believe in this matter, and why should it be admissible then or not admissible?
Well, I think that you have, I mean, there's no tie between these things being similar to the acts that here, and then you're alleging acts that aren't occurring recently in time to the event that happened, unlike our other cases, and you have acts that really aren't similar in kind as into the circumstances in which they arise, and you're bringing in a number of acts. So if you look at like Cox and Reynolds, you know, one of the things that they considered was how many acts that were alleged, and the fact that maybe individually they wouldn't have been prejudicial, but when you brought in so many, then they tipped the balance and were unfairly prejudicial against the defendant.
So other than what you've just mentioned, that is the number of prior acts that were disclosed to the jury, What other basis do you have for your contention that the probative force of the evidence was substantially outweighed by the prejudice?
Well, I'm not sure that, well, I don't, the fact that you look at, the 4 factors, need, clear proof, strength or weakness, and the fact or the degree to which it will prompt a decision for the wrong reason, I think here that the evidence of these prior acts is really weak as to showing whether or not he was justified in his reaction to her conduct. I see my time is up.
Thank you, Counsel. Ms. Link.
Good morning, Your Honors, Counsel. May it please the Court. Under a wealth of precedent from this Court and the clear facts of this case, there is simply no ground for finding that the District Court here abused its discretion. And we are here on abuse of discretion standard. To overturn the Court's ruling, you need to find that it is without basis in the extant law of this Court and without substantial evidence in the record, and that simply cannot be found here. The judge here admitted exceptionally limited evidence of the defendant's prior acts of domestic abuse in a domestic abuse assault case where intent was the issue at trial, the only really contested issue at trial.
How is intent an issue when the defendant says, I did grab her, I did do everything you said I did, but the only reason I did it was self-defense? So isn't the real issue at trial whether the self-defense defense was there rather than he intended to hit her or intended to grab her? I mean, he admitted everything the state alleged, if you read his testimony. The question is, did he do it in response to her attack, or did he not do it in response to her attack? So that's really the issue.
I have to disagree with that on both factual and legal ground. Factually, he did not agree to everything that the state accused him of and that the victim testified to. What he agreed to, and where the factual record was not contested, was that she did wake him up, that she had found the Facebook messages, and that at some point he had her pinned on the bed, that he later let her go, and at some point he claimed he grabbed her wrists after she swore about his children and said, I want you out of the house. She testified that he, after pinning her for a substantial amount of time, followed her to the couch and punched her repeatedly in the face, giving her a bloody nose. So that is different.
But both of those actions are assault. I mean, the degree of assault. But he said, I intended to do something to her in response to what she did to me.
Well, I think one could arguably be a defensive action. Punching somebody in the face is not usually a defensive action. But legally, this is a specific intent case. The state has to prove not simply that it was accidental, but that he had the intent to injure her. And that is the intent we are trying to prove, and that is certainly the intent that he denied throughout this case.
Well, if you look at some cases, like from the Eighth Circuit, there's some cases where you admit that you intentionally did the act. The prior bad acts don't come in. I mean, he admitted that he struck her, he admitted that he grabbed her, he pinned her, and things like that. So why, again, I mean, you're talking about the degree of his assault may be contested, but the reason for his assault is really the issue in the case.
Well, no, I disagree. Again, this isn't about a degree of assault. If the jury understood that the only act was him pinning her, that there was some argument that maybe she started it and he was simply trying to restrain her, because arguably grabbing somebody's wrists is a measure of restraint, you could maybe buy that he did not start the altercation, that he did not touch her with the specific intent of causing her injury. I don't think you can buy that when he's punching her repeatedly in the face, to the extent that his own mother, despite trying to play down what he did, admitted that at some point she tried to pull him off her, and in doing so tore his shirt.
Well, Counsel, that seems to go to who put on the most compelling case about how this altercation came down or went down. And I don't think that's quite where our focus needs to be. I think our focus needs to be on what is relevant given the state of the charge and the defense. My question to you is this. If our focus is, as Justice Wiggins has suggested, on whether or not there was a self-defense claim, should we view that as dispositive on whether the evidence of the other acts is admissible or not? Or is it your position that the evidence of other acts is probative whether we're focusing on the state's burden to prove the intent to commit the assault or the defendant's assertion of self-defense? Is it relevant in both contexts or just one?
No, I believe it is definitely relevant in both, and that
Why?
might be in part because I disagree with the distinction that's trying to be drawn here between the defendant raising a self-defense claim and the state needing to prove intent. When you're raising a justification defense, you are going at intent. That is the element that we are arguing here over. There's also a factual predicate that jurors would need to find about who started it. Was the degree of defense reasonable? But ultimately what you're deciding is the intent. He's obviously not going to be found to have defended himself if the jury believes that he very intentionally and willfully attacked her with an intent to injure her, and that is the entire point of the state's case here. Intent is clearly at issue.
So is the other act's evidence just as probative on the self-defense claim as it is on the state's other theory, which is you assaulted her with intent to hurt her?
Yes, I mean, again, I think that to me, they are two sides of the same coin. I don't think that there is a legal distinction there to be drawn with regard to the relevance of the prior bad acts, because they are, again, as you make the fact that he specifically intended to hurt her in a state of violent rage, that becomes more likely. The likelihood that he had a mild-mannered intent to simply calm her down and defend himself becomes less likely. I don't think that you can have one without the other. The
Counsel,
relevance is...
So assume just for the sake of discussion that you've vaulted over the probative force, the relevance side of the analysis. Why wasn't the evidence of these 4 other instances of altercation between Richards and the victim, why wasn't that prejudicial in this case?
Well, I think, again, to reframe the question is whether...
Bad statement of the question. Not why wasn't it prejudicial, but why didn't the prejudicial impact substantially outweigh the probative force?
Well, again, the question is whether the unfairly prejudicial impact outweighed the probative force. Obviously, if the state's offering it, we want it to be prejudicial to the extent it convinces the jury that he's guilty of this crime. That is what we try to do with all of our evidence. When this court has looked and examined the concept of unfair prejudice, the emphasis is on whether the evidence that comes in of the prior bad acts is the kind that will rouse the jury to overmastering hostility, that will cause the jury to decide the case not because they think that the prior acts convince them that they committed this act, but that they have an instinctual, emotional response to the prior bad acts that simply makes them want to punish. And this court has said multiple times that only in extreme cases will a limiting instruction, which was given here, be insufficient to combat any undue unfair prejudice in this case. Not only is there a limiting instruction, but this is across all of the cases cited in the briefs that I have seen from this court. This is the least amount of prior bad acts evidence I've ever seen actually before a jury. It has very little detail, and everything that they talked about is less severe, less graphic than the wealth of prior bad acts we typically allow in here, and certainly less than the actual charge
Doesn't the mere
offense.
fact that it happened, we talk about evidence of other crimes or wrongs should not be admissible to show that the person acted in conformity therewith. To me, this is pretty classic bad acts, prior bad acts testimony here. And then that means the state then has to go forward with enough evidence to say, well, we're doing it for a non-propensity type of basis. But everything that you're saying here, the emotional attachment, all these other things, to me, seems to be that, see, he's done it before, he's a hothead before, and you should believe her now because he's done it before. 4 different times. We have 4 different instances where he's acted aggressively. And so when you start tipping the scale, then who are you going to believe?
Well, that is when prior acts are properly admitted under the law of this court, and I believe most other jurisdictions, because it is going to intent. The idea is to suggest that when you have
I want to talk a little bit about that as well. I'm going along the same line with Justice Wiggins here. I'm not sure that intent, I guess to me, I'm just looking at it myself, but I'm not sure that intent was really at issue in this case. And even if I understand the theory that you have to show that he intended to cause a bodily injury in this case, and that's part of the state's burden, but what happens in his self-defense when either accidentally or intentionally, you know, somebody's coming at you, you swing out at him and hit him in the face? Isn't that something that the jury can decide about whether or not that was intended by him to cause the injury or not?
Well, certainly. I mean, nothing about admitting prior bad acts removes from the jury the ability to determine that under the facts of this case, he acted differently. I mean, that's simply not an issue here. Of course, that was a question for a jury, and the question went to the jury.
And you don't think that 4 prior instances of this has any impact on the jury then?
No, but it has the impact not only that it is supposed to have, but it is the impact that this court has recognized as valid over and over and over again. So I will go back to a question from Justice Mansfield earlier, that really in order to suggest here that the district court abused its discretion, this court would have to overturn its precedent. That has not been.
Where do we recognize it in a self-defense case, this court? Every case we have, you go to Sullivan, you go to Taylor, you go to Rodriguez, we find, you know, in Taylor, he said it was an accident. I didn't mean to do it. It goes to intent. This case, he says, I did it. I struck her. I caused her injury. I mean, if you read the transcript, I did it. So how does it go to the intent relating to his assault?
Okay, first of all, I will disagree factually again. He does not admit injuring her. He actually comes up with some very interesting reasons that she's injured, because her job is hard, and that's where she got the bruises. He denies.
He admitted he grabbed her on purpose. He intentionally grabbed her, intentionally pinned her down, and intentionally did this to her, which is the elements of the assault that you need to prove for domestic assault. So what I think what Justice Zager is saying, which my problem is, well, he did it before, he did it again, and everything he says is a lie. And that's the problem when you get to this point, when you have a self-defense, when someone says, I did it.
Well, I have to disagree. I think, first of all, in some of the domestic abuse cases, it's not clear whether there was, I mean, it was not part of the court analysis whether a self-defense argument was made. In all of them, the defendant denied hurting her. Some of them agreed that they touched the victim in some way. And I think the Court of Appeals has had a couple of those cases as well, but denied that there was any intent to injure her, that they slipped and fell after they touched them, that it was accidental. And this court has repeatedly held, without any substantial analysis or criticism, to suggest there's a problem.
If you read the arguments, he says, I did it. He didn't say, I didn't touch her, I didn't mean to hit her. In his final argument, he says, I grabbed her and did this stuff. That wasn't an issue.
I think that we might just have to agree to disagree on that. I do not think the record supports that statement. And he certainly testified to different ways that he speculated she obtained the injuries, which were not from him. And he certainly denied punching her.
You're referring to like Appendix 131, where he's asked, where did she get the bruises from? And he says, she's a very physical worker. She owns her own cleaning business, and she does the cleaning herself with her employees, so I don't. She's always hurt, you know.
Yes, there is also another point where he says that she scratched herself, and he denies any knowledge of where the blood
and this kind of drives it, you know, again, reviewing a cold transcript is kind of dangerous, but this strikes me as there's a fair amount of evidence to support the state's case, and I wonder why the state felt it needed the prior bad acts.
I think that there is a decent amount. I would like to think that in a common sense world that jurors would hear the testimony of the two and clearly find that the victim was the credible one and that the defendant's story was clearly not credible. However, this was predominantly a he said, she said case. He was not without injury. He had a couple of scratches as well. There wasn't really other corroborating physical evidence.
The record indicate how big I saw his testimony. He's 6'1", 230, supposedly acting in self-defense. The jury obviously would have had a look at the victim and could size up her size. Is there any indication in the record of what her, physical size is?
So not written in the record, like a reference to her size in the record. The pictures, I believe there's a picture that indicates she's pretty tiny. And they obviously would have seen her if I'm recalling the photographs that I saw correctly. But again, I think here, the reason that the state offered it is because regardless of the fact that most people would hopefully agree that the victim is more credible, you do have here an uncontested agreement that what precipitated all of this was the victim finding, and I see my time is up if I may finish, basically found Facebook messages indicating that the defendant was cheating on her, told him that, and said, I'm leaving. I think that there are plenty of jurors who would use that information and certainly buy into the defendant's, quite frankly, sexist, cliched stereotype of any emotionally distraught, crazy, psycho witch who flew at him, as he said, in a typical girl fight mode because she thought he was cheating on her. And I think, as this court has said multiple times, the domestic abuse prior assaults come in because we are very, very concerned about perverting the truth-seeking function of the jury by giving them an artificially sanitized record in which they think this is a one-off, and they don't see that there are repeated assaults, that the defendant routinely reacts angrily and violently. And that is why that is very important to help the jury understand the context of the relationship between the two and why it is much more likely that she was not the aggressor and was not the crazy, psychotically violent one here in the altercation.
Counsel, I'd just like to have your thoughts, your comments on the need factor. That consideration is one that puzzles me a little bit across our case law. How does the need for evidence affect the analysis? And the reason I ask is, sometimes it appears in the discussion of the state's need for the evidence. It's just sort of looking at the question of whether the state really needs it badly to get a conviction. That doesn't seem like an appropriate way to look at it. What are we looking at when we're assessing need for the evidence?
Are you asking more what role it plays in the probative value versus unfair prejudice? So I would agree with you that I don't think the precedent spends a lot of time in detail in explaining the tension perhaps there when, for example, prior bad acts might be gratuitous as opposed to something very essential to a case that could go either way. And I think that there are instances in which the state could be offering it in a gratuitous manner. So I think that there is, as part of a balancing that district courts do, their job is to look at all of the evidence and decide whether there really is a purpose for it to come in a way that actually matters to the trial, and that's something we entrust district courts to do.
So the focus, I take it your position is the focus is on the volume of other compelling evidence that the state has. That's really what we're talking about?
I think it is a balancing test. It's always in context with the other evidence. So what we look at in the probative value versus unfair prejudice is both how strong the prior bad acts is on the issue that we're offering it for. So how helpful is it to determining intent? Is it just sort of marginally probative, or is it very probative? Is it very helpful to the jury? Versus how much other evidence do we have? You know, I mean, is this, you know, if we can easily prove this issue, it's not necessary, versus how much of an emotional impact it's going to have. And so when those factors play out where it has a high probative value, that there is moderate to less evidence on the issue, and there's very little danger of unfair prejudice, it comes in. But if there's lots of other evidence and we think that there's a concern because the evidence is going to be graphic in nature, then there's a much less need for the evidence, and thus would weigh against admission in a district court's determination. Thank you, Your Honor.
Thank you, counsel. Rebuttal?
There's very little need for this evidence because you have, first of all, Tricia's statements. You have the mother's testimony and her statements to police. You have the police, reports of what happened. You have pictures from what happened. So there was very little need for the evidence, as there was lots of other evidence that they could draw from. This wasn't, a situation where they're totally alone and you had nothing else to go from.
The rule doesn't address how much evidence we're talking about. Isn't it just whether the evidence is probative to an issue at trial? I mean, it doesn't say that the state should get the evidence if it doesn't have any other evidence.
Well,
I mean, isn't this whole issue just about recognizing that evidence of this nature is always going to be prejudicial to the defendant, and we have to look at how probative is it to an issue at trial?
Right, and I don't think it is probative here because I described it as different circumstances, but I think it was probably better described as, justification doesn't have an intent aspect to it. You look at the reasonableness of the defendant's belief.
Well, his defense was that I didn't intend to harm her. My intent was to defend myself. So doesn't that enhance the probative value of these prior bad acts?
No, because they're not the same nature as what was going on here. So I think they don't assist in understanding the intent here. Go ahead.
Why don't we talk a little bit, because I think, as properly pointed out by counsel for the state, we're here on an abuse of discretion standard, and that's a pretty high standard if we're going to set aside a district court's decision regarding the admissibility of evidence like this. So how do you get around that high burden of showing that this has no basis in law or fact, or can't remember exact standard, but for an abuse of discretion, I consider that to be a pretty high standard. How do you get over that hurdle?
Well, I think the court said in, I believe it was Mitchell, that generally the statement is that the appellate courts lean towards the discretion of the trial judge, but what Mitchell says is the leeway is actually towards the trial judge more in the exclusion of evidence. And because with 404B, it's an exclusionary rule. So again, Mitchell says you lean more towards the judge's discretion when it is actually excluded.
The counsel, given our standard of review, you had earlier pointed out reasons you believed her testimony was not believable. Shouldn't we defer to the trial judge who heard her testify firsthand and give weight to the judge's credibility finding?
Well, when you look at the judge's credibility finding, one of the things he cites is he says, there were other witnesses, but there weren't other witnesses that actually testified that backed up, what she claimed. So I think that undermines the judge's credibility finding.
In addressing the discretion of the trial court, it seems like the trial court was very conscious of the issue that we're talking about today, and the trial court provided an instruction to the jury informed them how to use this evidence and how not to use it. The prosecutor did not mention the prior bad acts in closing argument, and the judge only admitted the evidence in a rather sanitized form, just a general description of the prior bad acts. Doesn't that minimize the prejudicial effect?
The evidence is still there. I mean, all the jury had to hear was that he assaulted her in the past. And again, they put in 4 different acts of assault. So
We
they
would
didn't-
have to overrule our prior cases if that's the standard.
Well, I think it's going to depend on maybe the circumstances of each case. But in this case, when you're talking about assault, that was all that was necessary. Thank you.
The Richards case is then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.